Okay, I'll go ahead and admit the parties.
Okay, thank you. Good morning. Are we all here? See, Mr. Kusandi.
Yes, I'm here.
Good morning.
Good.
Mr. Thalhuber.
Yes, this is Tristan Thalhuber. I'm here, and with me is Topher Tuttle.
Mr. Tuttle, thank you. Good morning. My name is Tommy Leung. I'm the lead judge for today's hearing. With me on the panel are hearing officer Seth Elsom and Judge John Johnson. Together, we will be equal participants in deciding this appeal. Uh, of some brief housekeeping matters before we get started. This appeal is being live streamed and it's going to be on YouTube. So um, I understand, I remember there are some documents like medical documents and bank statements that were exhibits. And Mr. Kosandi, I would strongly suggest that they not be shared on screen because all it takes is for somebody to take a screenshot and that information is out in the ether. And be sure everybody in the panel has those documents, and the franchise tax board has those documents. So if you wish to refer to them, just go ahead and refer to them. We can look at our own documents. There is a transcript being prepared by Zoom for today's hearing. For this purpose, we ask that everybody speak clearly at a normal pace and that we all not talk over each other. And of course, best practice is to mute our microphones when not in use. Prior to today's hearing, the issues that are going to be heard will decide are the late payment penalties and the dishonored check penalty for the 2021 taxable year. Is that correct, Mr. Kosandi?
Yes, Your Honor.
Okay, Mr. Thalhuber, is that correct?
Yes, that is.
Okay, so Ms. Kosandi, you will have 15 minutes, and the franchise tax board will have 10 minutes. Ms. Kosandi, you can split those 15 minutes as you see fit, and I will go on the record in just about now. So this is appeal number 2306-13538, Jacob Rastegar, MD Incorporated. Prior to today's hearing, today is March 20th, 2025. The time is approximately 9:35 a.m. As I was starting to say, prior to today's hearing, the parties agreed to the following items. Number one, that this hearing be held electronically. Number two, the issues to be decided are whether the dishonored payment penalty and the late payment penalty for the 2021 year should be abated. Number three, exhibits are being entered into the record for the taxpayer. He has exhibits attached to the opening brief and the reply brief. They consist of FTB notices, some bank statements, and some medical records. And for the franchise tax board, exhibits A through K, all these are being admitted into the record now. The appellant will have about 15 minutes to be used at his discretion for their presentation. Franchise tax board, 10 minutes. I would like to begin with introduction of the parties. For the appellant, please introduce yourself.
Yes, Parham Khorsandi, Pharmkhorsandi. I am the attorney for the appellants.
Good morning. Perfect. And for the Franchise Tax Board?
Yes, my name is Tristan Thalhuber on behalf of Franchise Tax Board, and with me is Topher Tuttle.
Yes, good morning. Thank you. Okay, Mr. Khorsandi, you may begin at your pleasure.
Thank you, Your Honor. We will reserve a few minutes at the end. I don't think I'll take the full 15 minutes for this hearing. So the main issue here is whether Dr. Rastegar has met the burden of proof to demonstrate that the late payment penalty and the dishonor penalty should be abated for reasonable cause. The circumstances surrounding Dr. Rastegar's severe illness due to COVID-19 do justify the abatement of the penalties under the Internal Revenue Manual that the FTB follows. We're confident that after reviewing our arguments and the documents that you will find Dr. Rastegar acted with ordinary business care and prudence despite his illness. We respectfully request that you consider this evidence provided, medical documentation and bank statements, and rule in favor of abating the penalties. So our position is Dr. Rastegar exercised ordinary business care and prudence. Section 20.1.1.3.2.2 of the Internal Revenue Manual does allow reasonable cause when a taxpayer exercises ordinary business care and prudence, but still cannot comply with the obligations. So the main issue here is that Dr. Rastegar contracted COVID-19, experienced severe symptoms, including extreme fatigue, dehydration, lethargy, and was in need for bed rest for up to 14 days. This is documented by his physician. Dr. Rastegar himself is an MD who deals with patients, and during this time, COVID-19 was rampant, and his urgent cares were the front line in helping deal with this issue, especially with younger children, elderly, and anybody who was walking into his urgent cares. So his contraction of the COVID-19 was really based on him being exposed numerous times throughout the day. And so when he did get COVID and did get the illness, it hit him pretty hard. Despite these debilitating symptoms, Dr. Rastegar made an effort to make his payment on the 2021 tax. And even while he was bedridden, he did attempt to pay, and that demonstrates ordinary business care and prudence. In addition, this error was not due to negligent, but just a mistake due to his illness. Section 20.1.10.7.4 of the IRM allows for abatement when the taxpayer had sufficient funds, but the error occurred due to some type of payment system fault. In this situation, Dr. Rastegar did have sufficient funds. It wasn't a matter of not having the funds. It was just an incorrect bank account that was chosen in order to cover the full 2021 tax bill. This dishonored payment was made because he had unfortunately contracted COVID and mistakenly selected a different bank account. We provided a bank account that shows the funds were there at the time he wanted to make the payment, and that was a mistake, again, due to his illness and not just pure negligence. Lastly, the Internal Revenue Manual does allow reasonable cause for the abatement of penalties due to extraordinary circumstances such as serious illness, which will prevent compliance. The physician's report for Dr. Rastegar outlines his debilitating illness, which made it impossible for him to manage his affairs, not only with taxes, but other affairs as well. However, in order to be compliant, he did make the attempt to make the payment from his residence, from his bed, but due to his illness, he was unable to choose the correct bank account. Despite these extreme circumstances, Dr. Rastegar made every reasonable effort to make that payment. We feel like that in itself, with the bank statement showing the funds were available and the physician's report, should be enough to demonstrate that the dishonored payment and the late payment penalty should be abated for reasonable cause. And we respectfully ask that you consider the evidence presented today and rule in favor of abating the penalties.
Thank you, Mr. Cossanti. I'll go to my fellow panel members. Hearing Officer Elsom, do you have any questions for Mr. Cossanti?
Yes, I did. Just had a couple questions. The first is just regarding the timeline for the payments. In the letter attached to appellant's request for appeal, appellant had stated that Mr. Rastegar had received the 2021 return and payment voucher on September 15th, 2022. And then he had made a payment at that time for the full balance due. But the date of the dishonored payment is one day prior on September 14th, 2015. And that was for $264,721. So I just wanted, I know these dates are very close, but I just wanted to reconcile and fully understand when Mr. Rastegar was aware of the payment obligation and when he had attempted to pay it. Was that tied directly to his receiving of the return and the payment voucher, or was he aware prior to that?
I believe it is connected to the voucher, sir.
Okay, so is it possible maybe the September 15th date is just an error, or?
Correct. Probably on or around September 15th. Yes, sir.
Okay. Second question I had is, can you provide the exact date that Mr. Rastegar received the September bank account statements for the bank account for which the dishonored payment was made on September 14th? And then follow-up to that would be, can you explain the extent of any delay in making payment subsequent to Mr. Rastegar receiving the bank statement?
Yes, I'm not sure how the bank statement was received by Dr. Rastegar. I'm assuming, like most of us in this Zoom meeting, these bank statements are sent electronically without a paper statement being sent. But what I am sure of is when he did notice that the account was not used and it was the incorrect account, he did go ahead and make the payment right away. It did take some time for him to realize that it was a different bank account. Again, under the COVID-19 illness, his memory was not as well as it should have been. And I'm not sure when he actually received the statements, but it was electronic. And once he did receive it, he did attempt to cure it by making the payment. And so that payment was made maybe a few months after the original September date.
Okay, thank you. And then I just had one last question, and this relates to the dishonored payment, but it's regarding a prior dishonored payment. So appellant had a dishonored payment on December 29th, 2021, which was later completed. Had a dishonored payment on December 29th, 2021, which appellant later completed in the same amount on May 2nd, 2022. Can you explain any differences in Dr. Rastegar's process of making that payment and verifying whether it was accepted by FTB and deducted from his bank account compared to the payment at issue here, which appellant attempted to make on September 14th, 2022?
No, I don't think these two dishonored payments would be related in any way.
Okay. Thank you, Mr. Cossanti.
Thank you, Hearing Officer Elsom. Judge Johnson, any questions for the appellant?
This is Judge Johnson, no questions. Thank you.
Thank you. Okay, Franchise Tax Board, please begin your presentation.
Thank you, Judge Young. Good morning. This is Tristan Thalhuber on behalf of Franchise Tax Board. Again, at issue in this appeal is first, whether appellant has established reasonable cause to abate the dishonored payment penalty for the 2021 tax year. And second, whether appellant has established reasonable cause to abate the late payment penalty for the 2021 tax year. Because appellant's return payment dated September 14, 2022 was dishonored, respondent properly imposed a dishonored payment penalty. When the respondent imposes a penalty, the law presumes the penalty is correctly imposed, and the appellant bears the burden to prove that it tendered the payment in good faith and with reasonable cause to believe that it would be duly paid. The Internal Revenue Manual indicates that a taxpayer may establish reasonable cause by proving that despite exercising ordinary business care and prudence, they were still unable to comply with the law. Specifically, the Internal Revenue Manual provides that If the taxpayer proves they had sufficient funds in the account to cover the payment at the time it was made, and the error was the fault of either the bank or the relevant payment system, that may constitute reasonable cause. Here, appellant contends that due to severe COVID-19 related symptoms, appellant's sole shareholder used an incorrect bank account instead of the bank account that had sufficient funds to cover appellant's total tax liability. However, appellant has not provided any evidence that it had sufficient funds in its bank account at the time the payment was submitted, or whether some bank error resulted in the dishonored payment. Furthermore, a taxpayer's error that is attributable to oversight is generally insufficient to establish reasonable cause. As such, appellant has not established reasonable cause for abatement of the dishonored payment penalty. As for the late payment penalty issue, because appellant did not timely pay its tax for the 2021 tax year by the March 15th, 2022 deadline, respondent properly imposed a late payment penalty. Again, the law presumes the penalty is correctly imposed, and the appellant bears the burden of proving that the failure to timely pay its tax was due to reasonable cause. Unsupported assertions are insufficient to satisfy that burden of proof. Here, appellant has not met its burden. Appellant does not contest whether the late payment penalty was properly imposed or computed, but rather asserts that reasonable cause exists to abate the penalty. Appellant argues that it was unable to timely pay its 2021 tax due because its sole shareholder tested positive for COVID-19 on September 13th, 2022, almost 6 months after the March 15th, 2022 payment deadline. Furthermore, appellant requests for abatement of a portion of the late payment penalty for the period after the aforementioned dishonored payment. As stated above, appellant has not met the burden of proof to demonstrate that the dishonored payment penalty should be abated for reasonable cause, and as such, the late payment penalty should not be abated from appellant's intended payment date until the actual payment date. Moreover, reasonably prudent taxpayers exercising due care and diligence are expected to monitor their bank account to determine if a payment was successfully made. While illness may establish reasonable cause, the taxpayer must present credible and competent proof that the circumstances of the illness prevented the taxpayer from complying with the law. Furthermore, an acceptable reason for failure to pay taxes will excuse such failure only so long as the reason remains valid. Again, appellant's 2021 tax payment was due on March 15th, 2022. And other than appellant's sole shareholder's positive COVID-19 test result dated September 13th, 2022, appellant has provided no proof that the illness continuously prevented appellant from paying the tax due until November 18th, 2022, when appellant's 2021 tax liability was fully satisfied. Thus, appellant has not met its burden to establish reasonable cause to abate the late payment penalty. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Thalhuber. Hearing Officer Elsom, any questions for the Franchise Tax Board?
I have no questions.
Okay, Judge Johnson, any questions for the Franchise Tax Board?
This is Judge Johnson, no questions. Thank you.
Okay, Mr. Corsani, I'll go back to you. You have about 10 minutes left, so any rebuttal?
No rebuttal at this time.
Okay, I'll go through my co-panelists one more time for any final questions. Hearing Officer Elsom, any final questions?
I have no final questions. Thank you.
Judge Johnson, any final questions?
Judge Johnson, no questions. Thank you.
Okay, I have no questions, and we thank everybody for participating in this hearing. I'm closing the record now. We will endeavor to have the opinion written and distributed to everybody within 100 days. Again, thank you all. Our next hearing for today will be 1 p.m. Again, good day. Thank you.